Brought to you from the state of Connecticut, capital city of Hartford, this is a Department of Developmental Services production.
Hi, I'm Dr. Peter Tolosano, Director of Psychology for the Connecticut Department of Developmental Services. The video presentation today is a new provider orientation. It will cover the following areas: Program Review Committee, Aversives and Restraints, Behavioral Support Plans, Data Collection, and Forensic Issues. The following area discussed is Program Review Committee. In 2018, the PRC, Behavioral Modifying Medication, and Behavioral Support Planning Policies and Procedures were consolidated into two, PRC and Behavioral Support Plans. There are three types of PRC reviews based on the number of psychotropic medications and aversives in each case. The reference point or threshold for the medications is the statewide average of 3. In the first type of review, for individuals below the statewide average, that is 2 or fewer medications, there is only the need to complete the psychiatric medication data entry form. In the second type of review, for individuals above the statewide average, that is 3 or more medications, with no addition of either new medications or new aversive components to their support plans, a packet needs to be submitted to PRC and a paper review is conducted. Lastly, all additions of new medications or the introduction of new aversive components require a full in-person presentation to the PRC by the team members for the individual served. Should questions arise about the behavioral support plan or the medication prescribing during the paper review in the second type of review, then an in-person presentation may be required by the PRC. We are hoping that all DDS regions will have a web link for electronic PRC submissions in the near future. PRC may apply to a variety of individuals that we serve: those who are placed under the direction of the DDS Commissioner, individuals who live in a DDS operated or funded, for example, intermediate care facility or community living arrangement, those who receive individualized home supports, those who receive waiver services where behavioral interventions such as aversives or restraint procedures are utilized, individuals supported by DDS-funded staff that administers behavior-modifying medication regardless of where the individual resides, individuals who are in DDS Behavioral Services Program when they are admitted to an in-state DDS-operated, funded, and/or licensed facility, and individuals who receive ongoing and planned psychiatric supports where behavior-modifying medication is prescribed regardless of where they live or whether or not they receive waiver services. Individuals may be exempt from PRC in the following ways: they only receive DDS respite services, they reside in a long-term care facility that is funded or overseen by another state agency, an individual is his or her own guardian or without a guardian, takes medications, and sees his or her doctor independently, and their interdisciplinary team agrees with the individual's decision. And lastly, an individual receives an exemption by the Program Review Committee and/or Human Rights Committee. There is a caveat that exemptions are for psychotropic medications only, and it never applies to aversive or restraint procedures. The following section applies to aversive procedures. They are defined as any procedure that contains the contingent use of an event or device which may be unpleasant, noxious, or otherwise cause discomfort to the individual. The procedure is experienced as negative or punitive by the individual. Aversives may include restrictions on personal freedom, such as door alarms, loss of privileges, room or personal searches, and line-of-sight supervision. Aversives should only be done in order to 1. Alter or avoid a specific behavior, and/or 2. protect an individual from self-harm or injury to others. Escort techniques, such as guide-along, that are met with little to no resistance from the individual, and hand-over-hand skills teaching techniques are exempt. Aversives include two types of restraint procedures. The first is mechanical restraint, which is defined as any apparatus used to restrict individual movement. This includes helmets, mitts, and bed rails that are used to prevent self-injury. Mechanical restraints may also include supports designed by a physical therapist and approved by a physician that are used to achieve proper body position or balance. The second type of aversive is a physical restraint. It is defined as any hold used to restrict individual movement or to protect an individual from harming himself, herself, or others. When documenting restraint procedures, the following information should be included: the specific procedure, such as PMT or CPI, the type of restraint used, such as lower figure 4 or supine floor control, an indication if it is a planned versus emergency procedure, the exit or discontinuation criteria, and lastly, data on duration and frequency of the restraint procedures. The next section discusses behavior support policy. The current behavior support policy discourages the use of coercive and punitive approaches. For example, spontaneous and planned ignoring, response cost, delivering consequences, etc. A suggested template for behavior support plans is available on the DDS website in the Psychology Division webpage. In terms of behavior support plans, regardless of the approach, whether it's positive behavior supports or applied behavioral analysis, a behavior support plan should include the following items: the author and the date when the plan was written or revised, a brief clinical synopsis regarding the individual, such as medical and psychiatric history, issues related to trauma, effective behavioral strategies in the past, and the current reason for the referral or update. The central element in all behavioral support plans is a comprehensive functional assessment. It helps to understand the reasons for the maladaptive behaviors and serves to anchor the corresponding interventions. A functional assessment should include a thorough description of the behaviors of a concern to decrease or eliminate, as well as the targeted positive behaviors for the individual to achieve. An emphasis on proactive strategies, such as improving communication, teaching alternative and adaptive behaviors, remediation of skills deficits, and enhancements to quality of life, such as preferred activities, should always be included. A plan may include reactive components to maintain safety in crisis situations. And lastly, behavior support plans should always have a method for data collection, which is most often tracked and reported on a monthly basis. All tables and graphs submitted to PRC should include a written summary where the data is interpreted by the behaviorist who authored the support plan. Moreover, interventional data should be compared to baseline data in order to determine the efficacy of the support plan. The final section of our presentation covers forensic issues. In DDS, forensics refers to the department's interactions with the criminal justice system and risk management procedures for those who are intellectually disabled and have had involvement with the court system. In the DDS forensic system, each of the 3 regions has a forensic liaison and committee that meets on a monthly basis. There is also a statewide forensic committee that convenes every other month to review significant cases and discuss policy-related issues. After the disposition of a case, the Department of Corrections, the Office of Probation, or the parole board may be involved with the individual depending on the sentence he or she receives. The issue of the defendant's competence to stand trial is a matter that may be raised by any party of the court, that is, the prosecutor, the defense attorney, the judge, etc. during the proceedings. A competency examination of a defendant may then be ordered by a judge. An Office of Forensic Evaluation team evaluates the defendant, and if the defendant is found not meeting the competence standards, the OFE must determine whether restoration to competency is substantially probable. Once OFE presents its opinion to court, the judge can make one of several findings. It may include not competent but restorable, and an order for restoration training by DDS within usually a 90-day period may ensue. Connecticut General Statutes 54-56D defines competency to stand trial, evaluation, and restoration. Competency under this statute is related to the defendant's ability to understand the charges against him and the potential consequences, to understand the role of professionals in the court, and to assist their attorney with his or her defense. Connecticut law creates no exceptions or special treatment for defendants diagnosed with intellectual or developmental disabilities. Another area worthy of mention in this domain is 54-56D subsection M, also known as not competent and not restorable. In this instance, the defendant is placed under the custody of the DDS commissioner for the purposes of applying for a civil commitment. In this situation, DDS has that individual is in its care and custody from the moment the order is issued, and the risk management aspect of the care will be reviewed by the Regional Forensic Committee periodically. After the court places a subsection M order, DDS must, within a reasonable period of time, file an application for a petition of involuntary placement with the appropriate probate court. While the department's obligation to the court is limited to the provisions of Connecticut General Statutes 54-56D, that is, competency to stand trial, the department may have some obligation to the person arrested, depending on our legal relationship to that person. Thank you for watching. We hope that you found this video informative. If you'd like additional information, please refer to the DDS website or your regional administration. Thank you.